put up, and I don't really have the control. If the organizers could give me the control for the slides. We've really been giving him a workout because he's been fixing the mic and running up and down. Thank you. Thank you so much. So just a brief overview of my presentation. I will give you a short rundown or a history of ICT, a global history, and hopefully tie that to what's happening here in Papua New Guinea, why regulation of the ICT space is so important, and then just updates on what we're doing in the ICT space in terms of mobile service coverage, spectrum reforms. And don't worry if you don't know anything about spectrum. I didn't know 12 months ago. And I was just reading a book last week by a very renowned professor in the ICT space, and he said, you know, your mother or your grandmother doesn't really care how the network operates. They just want to make a phone call. So I didn't really know about the spectrum space until I joined NICTA. So maybe at this point, I'll just add a disclaimer. One, I'm less than 2 years old in the industry. And two, please don't ask me the technology questions. If you do, I'll refer you to my team members over at NICTA. Okay, just a short history of ICT. In the 1800s, as you can see, 1837 and then 1876 was invention of the telegraph and the telephone. Those two devices were one person to another, so it's just two people communicating with each other. Then in 1893 and 1927, television, mass communication from one person or one organization to a lot of people. And then in 1893, it revolutionized the stage when the mobile phone was invented, the first mobile phone, I should say. And then the World Wide Web came. Who in university remembers, back in your PNG, if you remember, you sit at a computer and you turn it on and there's this sound that goes when your internet's connecting. So that actually happened between 1991 and 1993, and then the invention of the smartphone. So my boss likes to say that, you know, when the phones got smart, maybe we got dumb a bit, but I beg to differ. So, okay, maybe this device is not so smart, but yeah. So why is regulation important in the ICT space? And I'm gonna give you a quote from one of my colleagues from the ICCC. And again, like my dad, but he's not my dad, that particular statement that he made actually stuck with me for a long time. Why is regulation important? Regulation is important to, one, protect consumers, two, ensure that there's stability and predictability in the market, and also integrity of the industry. And most importantly, to promote fair competition. And when I say fair competition, what I mean is where the businesses thrive, but not at the expense of the consumer. It's an ecosystem that needs to be healthy and to be communicating with each other. And I think we all learned that lesson the hard way during COVID, that the ecosystem, as long as one chain is affected, everybody else down the line is affected. So the PNG ICT industry right now is worth 1.2 billion. And that's a lot of money. And for three players in the market, which is people like Telecom, Vodafone, Judicial, that's a lot of investment into the market. So I'll give you an example. Between 2018 and 2022, Judicial, don't quote me on this Judicial team, Judicial has invested a total of 800 million kina into products and services into this market. In 2022 alone, Vodafone invested over 3 billion into the ICT market in products and services. That's how rapid this industry is growing. So regulation is very important. It's important for the reason that I stated, maintaining an ecosystem where the consumer is benefiting, the businesses are thriving, and it's maintained that way through relevant policy and legal framework. So any regulatory lawyer will know this very well, that policy informs legislation. And so it's so important that as lawyers, as women lawyers especially, you're contributing in a space where you're giving 100% and you know that at the end of the day, you're serving your people and you're serving them well. So NICTA remains committed to fostering a competitive market. And when I say competition, this is where I'm going to quote my colleague on this. Back when I was at the ICCC, we did a submission to the NEC, and I asked him, please, could you just make just a little bit of edits here and there to our NEC submission, and let's make it, colorful. So when it's presented, they say, tick to Parliament. So this is what he said. He said, competition is the tried and proven way to efficiency, lower costs, and better quality of goods and services. Competition is central to the efficient operation of markets. It fosters innovation, productivity, and economic growth, which create wealth and improve living standards to reduce poverty. I thought that was a really, really, really good inclusion to my NEC submission. By the way, please, nobody tell him that I quoted him today. He's a very humble person. So for NICTA especially, we're committed to creating a landscape where the industries thrive, but not at the expense of the consumers. So, mobile service coverage. Now, who goes to their hometown and, is looking for coverage all the time and wondering, where's the nearest tower? I haven't climbed a tree yet, so I can't really talk about that. But I've had relatives who tell me that they've climbed trees to get coverage. So in terms of mobile coverage, there's 3 different networks. I'm just going to look for the screenshot that I took to help explain what I'm trying to present to you this afternoon. So there's 3 different types of network coverage. Who's heard of 2G? So there's 2G, there's 3G, and 4G. And there's some people out there who are saying, "Oh my goodness! As soon as 5G comes, that's Antichrist is coming." But don't fall for that. Yeah. So there's 2G, basic calls and texts. So you call like I said, your grandmother doesn't want to know how it works. She just wants the call to go through. So 2G is basic calls and text messages. 3G, fast mobile internet, and sharing photos, viewing videos, downloading apps. And then there's 4G, which is like so fast. So I think in this generation, we're so caught up on, we open our phone and we're like, oh, it's taking so long to download, even though it's 4G. So we wonder about overall coverage. So 2G, basic call and text, you'll see from the graph that's presented there, from the map that's presented there, total population of PNG is 11.7 million. 79% of the population is covered with 2G. So basic call and text, 79% of the population has access to 2G. For 3G, 8.9 million people have access to 3G, so that's 76%. And for 4G, also 76%. And this is something that we at NICTA are very proud to have pushed in the industry, to have access being given to our people, especially in remote locations, because it's very important for disaster management to have access to a reliable network. So that's just a basic table of what I've just presented in the maps. Now, there's something in the ICT space called closing the coverage gap. So 76% is covered. The remaining 34% is what we're working towards at the moment. And we're doing that with the ICT updates, which is the regulatory updates that I'm about to present to you. We're trying to close that gap through various little programs here, and not little, but big projects. Sometimes we're not as much out in the media to present the work that we're doing. And we're also working closely with our partners from both Judicial, Telecom, Vodafone, to roll out all these projects through something called the Universal Access and Service Program. So there's projects like connecting the schools, basic Wi-Fi services for schools. And recently we also signed a project agreement with the Department of Education to have all the curriculums uploaded online. So in any case where there's a disaster and children are unable to attend school, they have all the materials uploaded online. They can still attend classes actively from home. So there's Connect the Schools. There's also Connect the Government. And anyone heard of IFMS? NICTA's trying to work closely with the Department of Finance to roll out that program as well. So not roll out, but to support that program through the Department of Finance. So there's Connect the Government, and there's also Connect the Hospitals. Now, radio frequency spectrum. Now, that's what I spoke about earlier. I just recently found out last week, and after a year or so of working with NICTA, and I found out that spectrum is actually like a highway. And the different parts of the spectrum are like the lanes on the highway, which you put like different cars on. So you have big semi-trailers, then you have the smaller vehicles, and then you have like bicycles and motorcycles. So my colleagues sort of describe Bluetooth as the bicycle, the lower end of the spectrum. And then you have the mobile users who, phone calls and texts and all of that, which is like probably an SUV. And then you have the satellites, which is the semi-trailer. So it's right at the top of the spectrum. So it's the highway, and NICTA is responsible for licensing the players that come in and operate on the highway. So we have someone that comes in and says, oh, look, I want to provide a mobile network. Okay, sure, let's license you. Let's get you on the highway and let you provide the service to the people. So that's basically spectrum in a nutshell. I was going to use the board, and I actually asked for the board to be brought in, but I wore heels today, and I might collapse on the way to the board, so I'll probably skip that. I think I covered that. Let me just speed past it. It's a really colorful chart. I have no idea what it means, but I can also connect you to someone at NICTA who can explain that chart. So in terms of the reforms that we're making at NICTA in terms of managing a spectrum, I just want to go over something very important. So according to our legislation, spectrum is actually regarded as a natural resource. So as a natural resource, the government needs to manage it. And like I said, in terms of the licensing process. And it's a resource that's very limited, meaning that once it's assigned, it can't be, how do I put it? It's not like oxygen where it continues. Once it's assigned, it can't be taken away and given to someone else because the law has to protect the licensee. So we have been administering licensing of the spectrum through something called first come, first serve. So whoever comes first applies for the license, we license you. And then that license, you can hold on to it for 10 to 15 years. Somebody else can't come and take it off of you. Now, first come, first serve means that we may not be getting the best. The term they used was effective use of the spectrum. So I'll give you an example. And I didn't actually put it on my slide, but for a mobile spectrum in Australia, an annual fee for mobile spectrum is 23.5 million per year. In Papua New Guinea, mobile spectrum, PNG Kina, 439,000. Are we undercharging? Okay, maybe Australia is a really top-notch example, so let me take it down a bit. Let's get an equivalent of someone who's probably at the same GDP level. Namibia. No. Let's go with maybe Thailand. 43.3 million per year. And this is PNG Kina. And we are charging 439,000 per year. So the good professor that I was speaking to last week, I shall not mention his name, but he said, you have Central Business District downtown, right? And you have the high-rise buildings. Do you see someone planting cacao there? It's high real estate, right? They're not planting cacao in Central CBD, Central Business District, they're not. Where would someone be planting cacao? Gerehu, backyard? right? That's how we're supposed to be treating our spectrum. We have to charge it for what it's worth. So these are some of the reforms that the National ICT Authority is looking into. Maximizing use of spectrum. I feel like I've covered everything. I'll make sure this presentation is available so you can read through it in your spare time. But as I said, don't ask me the tech questions. So I'll just get straight to the ICT Act review. The ICT Act review is currently underway. Our good Minister Masio made an announcement, a formal announcement last year, I think in November, that the ICT Act is now under review. And this is something that we're going to go public with in terms of, consulting with the stakeholders, your input. Everybody's input is important, especially for driving. As I said, if we're charging $439,000, there's a problem somewhere. And thank you for your attention. That's all I have for today. And please feel free to come and see me anytime or send me an email if you have any questions. And if I can't answer it, I'll be able to put you in touch with those that can. Thank you.
Thank you, Kimberly. Very informative presentation. And I also just joined an ICT company, Judicial. So I also learned a little bit something from your presentation, so thank you. I do note that we have not allowed for question time, but do feel free to see our speakers after the program during our meet and greet and do ask them your questions. Our next speaker will be talking on strata title legislation overview. She's Sherry Lee Williams. I'm just looking for her in the room. She's on the side there. Thank you, Sherry. So while Sherry makes her way onto stage, while considering speakers for this yearly, we did put some thought into having young female lawyers come up and do presentations and to encourage them to, be part of the conversation and to put themselves out there. So thank you, Sherry, and Marjorie as well, who will be joining us, for accepting our invitation. So Sherry graduated from the University of Papua New Guinea in 2016 and completed her postgraduate legal training in 2017. She commenced her first employment with Ashest in June 2014 as a library and research assistant while doing her third year law. She then worked as a full-time lawyer after admission in 2017. In September 2021, she joined Lewin Sullivan Lawyers as an associate until December 2023, and she is now a senior legal lawyer with Credit Corporation. I think it is now Credit Bank? Yes. Ladies and gentlemen, please put your hands together for Sherry.
Good afternoon, ladies and gentlemen. Good afternoon, good evening. I think it's evening now. Ladies and gentlemen, and our esteemed guest in front. Thank you, Erica. So when Erica first approached me, I think in August, and Erica and I used to work with Lewin Sullivan Lawyers a few years ago. So she asked me if I could do a short presentation on the strata title legislation framework for PNG Women Lawyers Association. I was like, oh, okay, that's good. In my mind, I know that it's just us, the women folks, but yeah. But when I received the program last week, I was like, oh my goodness, why did I sign up for this? But anyways, I had to comfort myself. I was like, this is a good initiative, and also think of it as you're learning as well while preparing to do the presentation, and also you're assisting or contributing towards the legal education of the industry as well. I would say that I'm not an expert in strata titles, but what I'll share with you all this evening is basically from my experience as a property lawyer. I do a lot of conveyancing, and I practice in the commercial space of law. And also, I'll just share on what my overview of my understanding of what the legislations are. Okay. So, all right. Before I get into my presentation, can someone give me just a one word or one sentence of what they understand about strata titles? Volumetrics. Thank you, David. Yeah. All right. So, the presentation will basically we'll look at the definition, the introduction, background to the ownership of real property, because strata deals with property law. We need to understand how real property is held or owned, the common law. The legal framework of the strata scheme. I'll just give just an overview of the Strata Title Act 2022. The amendments, just highlight the main amendments to the other two land legislations. Give an overview on the Strata Title Management Act 2022, and then we'll just go through briefly on the advantages and limitations of the scheme. Now, strata title is a form of ownership of property that is devised for multi-level apartments, blocks that are subdivided horizontally, that is across. Vertically, you have it downwards from the sky down to the depths of the earth. Yeah. The strata part of the terms refers to apartments being on different levels or strata. So you have properties that are on different levels. Examples are residential flats, units, apartments, townhouses, office buildings, and commercial properties. As you all might know or have read in the papers, in 2022, the Parliament of Papua New Guinea passed 2 new legislation to provide for the establishment and the management of the scheme. Now, following these enactments, there were consequential amendments made to other related legislations as well. Sorry, I don't have them on the slides here, but just to name a few, we have the Physical Planning Act, the Building Act, the Valuation Act, the Survey Act, the Land Registration Act, and the Land Act. For the purposes of this presentation, we won't really go into those other acts, but we'll talk about the Strata Title Act and the Strata Title Management Act. Now, before we came in, I was asked by a few lawyers about the commencement of these legislations. There's a gazettal notice, G210 of 2023, which provided for the commencement of all these legislations. Now, most importantly, for the two-strata legislation, the notice stated that the acts would commence not less than 6 months from the date of the gazettal notice. So the gazettal notice was published on 27th of March last year. So I assume the act would have been in operation by now. We're towards the end of 2024, but that's just an assumption. I haven't seen any notice from the Lands Department, but I understand that they've been conducting several consultations in the last couple of months lately. Yeah. Okay. Background to ownership of real property. Now, at common law, a freeholder owns not only the surface of his or her land, but also everything above the surface up to the sky, and everything below the surface down to the center of the earth. Like I've said, vertical subdivision. Therefore, although subdivision of land was generally vertical at common law, the owner could dispose of a part of his or her land by horizontal subdivision as well as vertical subdivision. There is, however, difficulty in providing for separate documentary title to lots created by horizontal subdivision because the conventional way of describing land do not easily adapt to the horizontal subdivision. As such, registration of such interest was impossible. There are a number of approaches used, and the one that we've been using in Papua New Guinea for the last how many decades relies on company law rather than property law. This form of ownership, property ownership, is company title. Under this arrangement, the land is owned by a company called the body corporate. The company is specifically incorporated for the purpose of owning the land. Individual units are allocated to shareholders of the company according to the value of shares held, and the purchase of a unit is by way of purchase of shares in the company or the body corporate. So to own a property in an apartment, you have to buy shares in the body corp that owns the land which the building is on. So for this type of companies, they would always have a constitution which would confer exclusive rights to occupy a certain part of the building and determine the rights and obligations of shareholders regarding maintenance and use of the building. So for instance, if you buy shares numbers 1 to 5, then the constitution would state that, okay, unit 5 is allocated to the shareholder of shares 1 to 5. So a right of exclusive use of a unit is conferred on the shareholder by the body corp, does not give the shareholder a propriety right, but it only a personal right against the company. This right to occupy a specific unit arising from the ownership of shares is usually supplemented by a sublease created by the company to the shareholder. So when you're purchasing, you get a share certificate and also a sublease, a memorandum of sublease. The advantage of unit ownership under company title stems from the common provisions in the company constitution, restricting the rights to transfer shares and prohibiting leasing. The result is shareholders can choose their neighbors and control the nature and mode of use of the building. So usually if you have an apartment and you wanna transfer or sell to another person, then you have to get approval from the board of the body corporate. So you have to send your contracts and your transfer instruments, all of these things, and then you can proceed with the sale or settlement. There are two significant disadvantages. Purchasing of shares in the body corporate does not provide the shareholder with security of separate title and ownership. It merely creates a contractual right against the company. Consequently, the shareholder might find it difficult to raise funds on the security of the unit. Number two, title is vested in the body corporate. As such, rights in respect of the property and each unit must be exercised in the name of the body corporate and not directly by the shareholder. I'll just give you an example of that. So a few years ago, I was dealing with a matter where we were acting for the seller who owns an apartment. We were in the process, I was doing my due diligence on to ensure that the sublease was properly registered and find out where the titles are and all of that. And in the process of doing that, it was an urgent sale. They wanted to get it done. The buyer had the money available and was willing to transfer it to our trust account to hold while the sale process is going on. We found out that the head lease, which the subleases were registered under, had expired a few years ago. And that meant that the sublease that our client had is based on a lease that is non-existent. So what we could do is we had to reach out to the body corp to get them to fix the head lease so we could create or draft new subleases again, and they have to be registered again on the head list before we proceed to the sale, and that could take, getting the head list renewed would take a couple of months, and then dealing with the registration of the sublease. To make it worse, the body corp wasn't functioning as it should be, didn't have a legal representative at that stage, so for the purpose of progressing the sale, we had to step in and assist the body corp, we could prepare templates for the subleases and you can amend for the different unit owners. We had to discuss on costs. They were not willing to pay for our fees. So you can imagine our client couldn't sell the unit in a timely manner. It dragged on for, I think, 2 years or so. So the legal framework of the strata scheme. Under the current formal system of land registration, it's based on the torrent system. Basically, you have ownership of the property, or ownership is transferred once the transfer is recorded on the title deed. The torrent system was initially introduced in PNG under the land legislation adopted from the Australian Capital Territory. So to ensure that we keep with this historical feature of the PNG Land Registration Act, both strata legislations are based on the Unit Titles Act 2001 and Unit Titles Management Act 2011, currently enforced in ACT. To understand how the scheme works, we must read the Strata Title Management Act, Strata Title Act, and the Land Registration Act all together. Okay. I won't go into the nitty-gritties of the Strata Title Act, but I'll just give an overview of what's important. There are some new key features or new terms introduced under the Act. such as common property, which means all parts of a parcel identified as common property in the strata title. Owner, when you're referring to a unit, it means the owner of the unit, lease of the unit. If you're referring to the common property, that's the owner's corporation. So there are two types of owners. Parcel means the land that is proposed in the strata title application to be subdivided, or the whole of the land subdivided as shown on the strata plan. Strata plan is the diagram showing the subdivision, schedule of unit entitlement, schedule of rent, the rest. Units are part of the parcel. What would normally be apartments in a building. And unit subsidiaries are part of a parcel identified as a unit subsidiary, and they are annexed to a unit in a strata title application. These include car park spaces, laundry, recreation area. The Act provides for the division of buildings by the grant of a separate certificate of title to the parcel of land that have been defined by horizontal as well as vertical subdivision. The scheme under the Act provides for individual lot owners to share certain facilities like gardens, stairways, or the lifts on the part of the building. These shared facilities form the common property. In addition to the common property, there are certain easements may be granted to make the scheme viable. For instance, under sections 36 and 37 of the Act, it provides that the boundary between each lot is considered as the entry of the relevant structure and an easement of support necessary to preserve the structural integrity of the adjoining lots or the adjoining units. So how do you get a certificate of title in a strata scheme? Under the Act, there are two parts to get to it. The process starts with the strata title application. Basically, the application is made so that the Department of Lands can assess whether it meets the qualifications or the criteria under the Act, and if it does, then it progresses on to the next phase. But if it doesn't, then they'll ask for more information or missing details. The application can only be made in relation to a parcel that is a subject of a state lease, where the remaining term of the parcel is at least 50 years. So if you have a lease that is expiring soon with a term of 10 years or so, then you might have to renew that lease before you apply for strata. Only the lessee of the parcel can make the application to the head of the department for the subdivision. The application must show how the parcel is to be subdivided. So when you're submitting your application, you must show how the parcel or the land is to be subdivided. And that is Class A units. Class A units, if you're gonna build a high-story or multi-story building, then you have to show the plans for that. Class B units are like townhouses. They are unlimited in height. The application must also show the unit subsidiaries, like the car parks or the balconies that are attached to the units themselves, and also the common property of the building. If the application is made in relation to an existing building, the application must include a plan prepared by a registered surveyor and a strata title assessment report. The report must provide information regarding the description and location of the land, details of the applicant, date of the report, certificate of completion issued in relation to the building. So to submit your application, you have to be talking to the surveyors and all these other tech guys, technical people, I guess, building board and all of this to get your documents in order. So if the application is for a stage development meaning there's no building on the land and you're preparing to develop the land, a development statement must be provided as well. The statement must provide the information on the description of the land, plans relating to the development approved under the Physical Planning Act. It must state how development is to be carried out, description of the work, schedule of the commencement and completion dates for each stage, and how access to the site is to be granted. Once each stage is completed, the applicant will be required to submit a survey plan and a strata title report. After the application is submitted to the secretary and upon satisfaction that the application is in accordance with the act, the head of the department may approve the application and will give notice to the applicant. The notice will also enclose diagrams showing the subdivision and the development statement if it's for a stage development. Once the applicant gets the notice, next step is to submit the plan of the subdivision. It goes to the secretary for endorsement. So once the secretary endorses the plan, the lessee of the secretary will give the applicant, will issue the strata plan to the applicant, and the applicant will have 3 months to register the plan with the registrar of titles. So usually you would have to liaise with the alienated lands division at lands department, who deals with leases, state leases, to follow up on applications. Okay, sorry. We'll talk about registration of the plan a bit later. But now I'll just jump on to another part of the act. So you have say you register your strata plan and you have your certificate of title. Now what happens to your title if the building is damaged? Because basically the certificate of title you have is for the units in the building. So if the building is damaged or destroyed, there is a building damage scheme under the Act. If you want to read more on that, it's under sections 45 to 50. And I believe that during this time, services of litigation lawyers are needed to make the application to the National Court for a provisional building damage order to approve the scheme. The scheme can be for the reinstatement of the building, elimination of any Class A unit that will not be reinstated, and if there are consequential amendments of the strata plan, that will also have to show. If there's any insurance amount, insurance money paid for the damage or destruction to the building, how that money is going to be applied, and the payment of compensation or other money to the owner of any unit who may be adversely affected by the scheme. The Act doesn't provide much criteria that the court is to consider to grant a provisional building damage order. All it says is that the court may grant the order if it is just and equitable to do so, and may order any other make orders on any other ancillary matters to give effect to the provisional building order. A strata plan can be cancelled upon an application by the owner's corporation for a cancellation authority. Now, the cancellation authority is made to the Secretary of the Lands Department, or the owner's corporation can apply for a cancellation order to the National. On the registration of a cancellation authority or cancellation order, the strata plan is cancelled and the owner's corporation is dissolved. The lease of the common property and the unit ends and a new lease arises over the parcel. The new lease held by the owners of the units before the registration of the authority, before the registration. Sorry, I'll read that again. So basically, the new lease is held by the owners of the units as joint tenants in common. So say before the state lease was surrendered for the grant of a strata title, whoever owns the state lease becomes the owner of the new lease. Okay. Now we have to jump back to the registration of the strata plan. So the Land Registration Act, Amendment Act 2022 was enacted to allow the registration of a strata plan by the Registrar of Titles. So remember when earlier on when I said once the head of the Secretary of Lands gives the applicant a strata plan, the applicant has 3 months to register the strata plan. So the applicant will take that plan and go to the Registrar of Titles to register it. It is upon the registration of the strata title plan that that a certificate of title is issued in respect of the units. An owner's corporation is also established upon the registration of the strata plan. Any state lease over the relevant parcel ends, and a former holder of the state lease or the applicant becomes the holder of each lease or unit in the strata plan and is given a certificate of title for each unit on the same terms as the cancelled state lease and ending on the same date that the cancelled state lease would have ended. Okay. Where's Catchment? The owner's corporation becomes the holder of the lease of the common property. I think we discussed that. Where the previous state lease was subject to any mortgage or was subject to or the beneficiary of an easement, the lease applicable to each unit is similarly encumbered. Apart from the Land Registration Act, there was also a small piece of amendment made to the Land Act 2022. Basically, under the Amendment Act, there is a new type of state lease called a strata development lease. Now, if you read the Land Act, there are different types of purpose that the Department of Lands issues state leases for. It can be for residential purpose, business, special business agricultural purpose. You have a mission lease. Now we have a new one, which is the strata development lease. A strata development lease allows for the subdivision of land or the vertical subdivision of building in 2 or more parts. The purpose of the subdivision can be for convenience, transfer, partition, sale, gift, lease, mortgage, or any other purpose. The lease can be granted on land where there is an existing lease. In that case, the applicant has to surrender the state lease and must ensure that the tender document is accompanied by a sketch plan of the infrastructure of the proposed strata development. Now, I've seen that for this type of leases, the Lands Department uses a term called greenfield. If you go to the website, you'll actually see it. Greenfield, and they have brownfield. Brownfield are for leases which already have buildings on it. The owner of a building under a subleasing arrangement can surrender their subleasing arrangement in exchange for a strata development lease. So subleasing arrangement, remember company title we spoke about? You own the unit by way of buying shares, and then you get issued with a sublease. Okay. All right, so how do you manage the scheme? I believe that for buildings that are, that have maybe not more than 5 units, it's easy to manage. But say you have a high-story building with 12 or 15 different floors and then more than 50 units, then obviously it has to be managed properly. So under the Torrens title system, the proprietor holds title over the land vertically. This means when you are the sole owner of your property, you can choose to make any changes or maintain the property at a time that suits you. There are no rules restricting the owners of a Torrens property, such as owning a dog or a cat, or you having a barbecue on your veranda, or playing your music loud on a weekend, or hanging your laundry over the balcony. But with strata, any maintenance to common property is outsourced by the owner's corporation and is covered by the strata fees. A strata managed building can see less disputes between residents due to the fact that there are some rules in place outlining the expectations of the occupants. Under the Strata Title Management Act, it establishes the Owners Corporation. The members of the Owners Corporation are the owners of the unit that are disclosed in the strata application. The Owners Corporation has the legal status of a corporation and may sue and be sued in its corporate name. The obligation of the owner's corporation to manage and administer strata property includes a range of powers and duties. And the first one includes the power to make bylaws. There are requirements under the Act on how it should amend those laws or rules and consequences for not adhering to those rules. Schedule 4 of the Act also states several standard rules that applies to while the owner's corporation, it has the power to amend or add its standard rules, it cannot make rules that are inconsistent with those rules that are set out in Schedule 4 of the Act. Another obligation of the owner's corporation is to maintain and repair the common property. To do so, an owner's corporation may delegate its powers and duty to such persons prescribed under the Act to carry out some of its functions. The Act allows the owner's corporation to establish an executive committee to help it to carry out its functions. I think I'm going a bit over time, so I'll just wind up. Sorry about that. All right. Financial obligations. The owner's corporation has powers to establish funds, basically two funds: the administrative funds, which is used for general administration of the owner's corporation, and the sinking fund, which is used for capital expenditure of the strata building, for example, painting or repainting of the building. Okay. Insurance. It must ensure that the building is insured against damage. Records. Keep appropriate records of accounts of information to each unit owners. And it can also invest funds of the corporation. Advantages of the scheme. So the strata title scheme may be a costly and time-consuming process. However, the long-term benefits may outweigh the initial outlays. From the perspective of a unit owner, they'll have certainty and proprietary rights over the units. This will also benefit them with an increase in the property value and also opportunity to sell the units to a wider pool of potential buyers. Provides from a financial, from the perspective of a bank, a financial institution, it provides certainty to banks and financial institutions and the ability to register mortgages or other encumbrances over individual strata titles in the buildings. Banks and financial institutions can easily enforce their rights as mortgagee in the event of a default and sell off the unit in a mortgagee sale. The documentation and registration process to deal with the selling of a unit is much more simpler than under the company title scheme. Unit owners do not have to deal with the transfer and registration of shares in the body corporate. And unit owners can hold the executive committees of the owners corporation accountable for any breach of code of conduct if they're not managing the the buildings properly or in accordance with the rules. Sorry, I'll just run very quickly with this. Limitations of the scheme. While the Act contains substantive provisions necessary to establish a strata scheme, their limitation, the application can only be made in relation to land that is subject of a state lease and has a term of at least 50 years. Freehold land and registered customary land are not subject to state leases. As such, care must be taken to ensure that upon registration of a strata plan over a parcel, the extinguishment of that parcel's underlying lease is not mistaken for a means to convert the freehold or registered customary land to state lease land. The Act does not contain provisions for existing building owners under a subleasing arrangement to transition to the new strata title scheme. As such, my understanding of it is that it is voluntary for building owners operating under the existing subleasing arrangement or the company title to decide whether to continue to operate under the current scheme or to apply for strata titles over the particular buildings. And the last limitation is, unlike the strata legislation in Australia, the Acts do not include a disclosure regime requiring minimum disclosure requirements to be satisfied when a strata unit is bought or sold. All right, I think that's the end. I'm sorry if I've gone over time. It's a new concept to all of us, so from the first sight, you might have to do your own reading, and there are some more simplified versions or requirements in relation to the scheme on the Lands Department website, so in layman's term. So if you're interested in that, you can read up on the website. Thank you.
Thank you, Sherry, for your very detailed presentation. It does take time and effort to put together a presentation like that, so thank you. Our next presentation is on how to draft an effective will, and we have Marjorie Tamutai from Namani and Associates who will be presenting on that. As part of her bio, she is a part-time lawyer and a full-time mom, so I think that's the same for the rest of the women in here as well. So Marjorie was admitted in January of 2021. She joined Tamutai Lawyers as a graduate lawyer and then moved over to Namani and Associates, where she mainly does commercial work and some litigation as well. So ladies and gentlemen, please put your hands together for Marjorie.
Okay, good evening, everyone. Good evening, Chief Justice. Sorry, I'm a bit shorter, so. Your Honor, the Chief Justice of Papua New Guinea, Segi Bumagib Salika, the President of the Law Society, Mr. Hubert Namani, the Commonwealth representative of in Papua New Guinea, Mr. David Denningston, and our keynote speaker, Dr. Manu Matavai Tupo Rusin. Yes, and good evening to everyone. Okay, so today I'll be talking about drafting, effective will drafting. So wills are considered as, I'd say, like the elephant in the room. people don't like to draft wills because of this superstitious belief that, you bring your death closer when you draft a will. So, I'll begin by talking about what a will is. So I'll just take you back to our LTI days where we learned what a will is. So a will is defined under the Wills, Probate and Administration Act. It's provided for under Section 1 of the Wills and Probate, WPA. So there are 6 definitions as provided for under the Act. The case of Wagun versus Pilambo, Justice Makal in that case went on to specifically define a will by adopting the dictionary definition, which is a will is a direction written in legal form for deposition to be made of a person's property and minor children after his death. So put simply, a will is a legal document surviving the death of a person that contains his or her wishes on how he wishes to distribute his or her property. So, now, in drafting a will, how do we obtain instructions from client when drafting a will? So we begin with getting the information from the testator, their full legal name. Full legal name as in the name as per their NID or passports, their occupation, addresses, all that. The testator must be 21 years, above 21 years, or to be eligible to have a will, basically. And the will must be written in a language that he or she habitually uses. So if the will is written in another language that he or she does not habitually uses, there must be a certificate of translation annexed at the back of the will, confirming that it has been translated to that particular language that the will is written in. Okay, moving on to the beneficiaries of the testator. So basically, a person who, when the client drafts the will, he or she chooses to name whoever that he wants to distribute the property to. So it could be the children. The children and the wife are usually the common ones, yes, but they can also choose to give to some other relatives. Yeah. Okay. Oh wow, a baby. So if the beneficiaries are under 18, that means the testator has to appoint a guardian. So the guardian is the one will be the one responsible to hold the benefits in trust. So usually, yes, it is advisable for clients to appoint guardians for beneficiaries under 18. So the testator may also appoint, the guardian can also be the person that is responsible to take care of the minor's children of the testator, yeah. So basically, the Lookout in Pikinini Act, under the Lookout in Pikinini Act, it also provides for a custody application for such a person appointed in the will. Oh yes, so I forgot to mention, it should be in the inception. Actually, the full legal name of the guardian is required. Okay, moving on, the client, we must obtain instructions on the executor or the executrix. Executor is if the person named is a male, and executrix is for if the person named is a female. So it is advisable for clients to obtain consent from the person who they wish to name as the executor. They must obtain consent from them before they put them down as the executor. And also, it is advisable to have the clients notify the executor where they want where the will be kept, the signed will be kept. So in the event that the testator passes on, the executor knows where the will is kept, so they can enforce the will. So we must get the full legal name, their postal address, and all that, and then identify the powers in the will. But they're also governed by the Trustees and Executor Act. So we had a client coming in, and I tried to explain to him about the fact that there's a legislation for executors, and he was so surprised. Yes, okay. So you can also obtain instructions to name an alternate executor. That's if the primary executor would be unable to perform his duties. The solicitor, as in the lawyers who will be responsible to enforce the will when the testator passes on. So payment of debts and expenses, usually it's provided for under Section 70 of the Wills Probate Administration Act, where the debts and expenses of a deceased has to be paid off first before the properties are distributed. So it's advisable to just inform the client and include it in the will. We had an instance where we drafted a will for a client, and the client was reluctant to include that particular clause, and I said, oh, look, it's mandated by the legislation, so we don't have a choice, we just have to include it. Okay, now to the details of the assets. So make sure to get it's advisable to get the proper description of the land, state, list, volume, folio number. For customary land, usually sometimes clients prefer to include it in the will, but most cases, like in PNG, we know that for customary land ownership, it's it passes on by way of custom, so you know who owns the land, so it doesn't need to be in the will, but some clients, they like to put down the wishes. Motor vehicles, make sure to get the model, engine number, chassis color, all that, details. Chassis, sorry, pardon. So we have bank accounts, IDBs and all that, details. Shares in companies. Oh, nice jewelry, and yes, jewelries and clothes. So ladies like to, when dealing with clients, women clients usually like to include their jewelries in their will. So we just adhere to instructions and then we incorporate that part in the will. But for males, when I ask if do you have any jewelries or clothes that you would like to include in the will? And then they just say, no need. Okay. And pets as well. We include pets, full name and description, paintings. Okay, then the most important part of it is the allocation of the assets. So obtain instructions on how the client wishes to distribute his or her assets. Okay, for residuary estates, these are in all legal drafting that we do, we like to have a safety net, what if this happens, what if that happens. So basically that particular clause may capture in the event that the beneficiary passes on, and you don't, in the event that the beneficiary passes on and that will is not updated, then that particular clause sort of captures how their share passes on to the next, So, yes, that's like a safety net, I'd say, safety clause. Okay, now to the most, the death. Okay, now, so there's a clause that may be included, not may, it must be included, because that's the purpose of the will. Okay, for the death clause, we include funeral services, how the client wishes to conduct their funeral services. Some clients, they go to the nitty-gritties of what songs they want they want it sung, what clothes they want people to wear. They also draft up their funeral programs, and then so we just put it in. We had a client changing instructions, and we had to first she wanted something else, and then she sent instructions again. She was like, no, it's fine, I want to be cremated. So, okay, we changed it again. Okay, so then the place of burial, and whether, they want to be buried with full body or cremated. Okay, so there must be 2 witnesses to the will. The witnesses may not be they will not have the benefit of reading the will, but they can just so that they can attest to the fact that he signed the will or she signed the will. So there's to be 2 witnesses to the will, their full legal name and address. So a beneficiary or the spouse of a beneficiary cannot be a witness to the will. So it's per section 19 of the Wills and Probates Act. Okay, now to execution. That's the most important part. The execution of a will is the most important part, and it's provided for under the legislation itself. So, how can our client execute his or her will? You make sure that the testator and the witnesses sign at the foot of the pages of all the will. That's per section 13 of the Wills and Probate Act. Now to the next. After the will is signed, where can it be kept? So a signed will must be kept in a safe place, basically. But it is advisable to keep it in different places, and the executor must be aware of where the will is kept. So updating a will. So after a will is signed, can it be changed? So a will must be changed if the executor dies, or when the testator has children, if the testator gets married or divorces, or when one of the beneficiaries dies, or if the testator acquires assets or liabilities, they have to update their will again, or there is a substantial change with gifts or assets specifically gifted to someone. Okay, now to the last part, to the enforcement. How can I enforce my client's will? The National Court has the jurisdiction for all properties within Papua New Guinea. So usually some clients have properties in Papua New Guinea. They may also have it in Australia. For this case, they can enforce apply to the courts to enforce the will here in PNG, and then later bring it down to Australia and then have it enforced again. So the executor is the one responsible for, firstly, they apply to the courts for a grant of probate after the testator passes on, and then secondly, the eventual distribution of the properties of the testator. Oh, so for now, for questions, we're not gonna, because of in the interest of time, we may not have any questions, but there'll be no questions taken now. But feel free to see me after and ask me questions. Yeah, I think that's all. Thank you.
Thank you, Marjorie. So now you all know how to draft an effective will. Okay, so our next part of the program, we are launching our legal aid directory. So we had to start somewhere, start small, go big, so here we are. One of our key objectives is to provide pro bono legal services to women and children who are victims of family and domestic violence. So PNGWLA made a call to lawyers who would like to volunteer their time to provide services to mainly women and children who are victims of family and domestic violence. And this directory that we have put together will be kept initially at Mary Safe houses. And then we're planning on having a legal aid forum next year where we can upskill and keep our volunteers updated. And if anyone also, or any firm who is willing to also provide that service and partner with PNGWLA, we welcome you. And I would like to especially thank our volunteers. We have about 13. So we have Novada from Nova Lawyers. We have our secretary, who is not here. She's on duty travel, but she has also volunteered her time, Raka Raula Numa. We have Sharon Ignas, Marjorie Tamutai, who just presented on how to draft effective wills. We have Gloria Salika. We have Stephanie Alopia, Eunice Kapu, Hezron Wangi. We have Nathan Palem Onom from Palem Onom Lawyers. We have Joanna Kabewa. We also have Samson John Hirawa, Eunice Wangu, and I'll just add that Eunice Wangu was the Supreme Court awardee, just recently passed out from LTI, so thank you, Eunice. We have Vanessa Rambua, Marilyn Coim, and myself, so thank you, everyone. This directory will, for now, be at Mary Safe houses, and in the event we have more volunteers, we'll keep it updated. So thank you. I will now call upon David Denniston to give the closing remarks. Thank you, everyone, for your patience.
It's an intelligence test. Thank you very much. Just on behalf of the CLA, I just want to show our gratitude and give all the plaudits to the PNG Women's Lawyers Association for putting on this event. And I know you did it very quickly at short notice, so it's a major achievement. It took us about a year to do the same thing. But for anyone who hasn't heard me talk about the CLA in the past, we're a rule of law organisation throughout the Commonwealth, and we mainly comprise republics, large countries, tiny countries, and we're becoming quite strong in the South Pacific. We're looking for a council member from Tonga, so I'm going to talk to you later, Dr. Manu. But we support the PNG Law Society and their rule of law efforts, the Rule of Law March, their statement on the violence in East Sepik, and they're also going to cooperate us on our project to get PNG measured in the World Justice Project Rule of Law Index, which we hope to spread to Samoa and Fiji next year. I commend the PNG Women's Lawyers Association on the launch of the support to women and children who are subject to violence, family violence. Just this week I was speaking to the Tribal Foundation, and that's another organisation you might want to consider supporting, because they tell me that one of the biggest deterrents to family and sexual violence is charging and getting sentences against the perpetrators of family violence. And they were very instrumental on the amendments to the Criminal Code, where they've defined SARV. But Dr. Manu, what a powerhouse presentation. I didn't expect to get a lesson on life skills and to learn about your work. It's truly inspiring. And I hadn't realised the problems of movement of fish into the high seas. So it looks like PNG is going to lose out, which is no good. Kimberly, thank you for your talk tonight. I suppose no one asked you about Elon Musk's satellites. We could have had Chatham House rules, and we could have told us a bit about that. But I had no idea that spectrum's a bit like mining leases. If you don't use them up, you might lose them. That was very interesting. Cherie, we miss you at LLS. Your attention to detail was the bedrock of our property section. We might have to get you back as a consultant. And I had no idea you could do horizontal title on common law, freehold title. And I do have some questions, and one of them we'll talk about later is if the new strata title torrent system will act like the torrent system is meant to act and be a title by registration. That's a question on notice. And the wills. Can you do a will cover me for here and Australia, Hubert and Marjorie? Are they much different? I might need one. So I'm just wondering how you instruct a lawyer after you have deceased. Do you put that? I might have misunderstood, but does that go in the will? Yeah, lots to think about there. But anyway, another plug for the CLA. If anybody, as Chief Justice said last month, if anyone's interested in coming to Malta, and after that having a chance to knock me off, which is his words, come and join and nominate. We've got quite a growing membership in PNG, including 2 young CLA representatives now. One is here, Loretta, and Peggy's back working. So thank you very much. Have you got something else now, Erica, doing gifts? All right. Thank you.
We have a little token of appreciation gifts to present to our keynote speaker. So I'd like you to come up and receive your gift. You?
Sorry, Michelle. Vice President Michelle Pin, on behalf of the FFA, we have a small gift in return. It's our Pacific Way, and we really appreciate the opportunity to share FFA's story. Thank you.
Thank you. I didn't expect that. Okay. Thank you very much. I'd say we are privileged to have you and to know more about what you do in the fishery industry. And I think for tonight we've learned a lot, I should say, and it's important for continued legal education to continue in our different walks of life. So we may, we work in different industries, or we practice in different special areas, I should say, and it's always good to know about what another colleague does in their space of work. So I think information sharing is important, and for all of us to know and develop our legal profession and the way we practice and for nation building. So thank you all for coming, for your patience, time. It's invaluable. And we appreciate PNG Women Lawyers Association, and we look forward for more joint collaboration with PNG Judicial Excellence and PNG Law Society, and sorry, David, Commonwealth Lawyers Association. But yeah, thank you. And you all have a safe trip back, and I believe cocktails there, so we'll just enjoy, mingle, get to know each other. And of all, sorry, I'd like to mention while we were taking registration, LLB3 student is here with us. And I think he's the only one that got registered today with the rest of us, so thank you. If you can stand up, and I think you have potential employers here, or so yeah. I was so impressed, and I told him, you're ahead of your schoolmates, like you're involved in this kind of legal education. It's very important. So thank you, and to everyone as well. And thank you, Erica, for pulling everything with the committee here. So kudos to that. And Simon, for your help, thank you as well. Oh, and yes, sorry, before we wind up, to the closing prayers. Thank you.
All right, thank you, Michelle, and thank you, everyone. Close your eyes and I'll do the benediction. Abba, Father, we remember the story of Miriam. When she faced the odds and the tyranny of the day, she still withstand the challenges of River Nile and was able to bring solution back to her own home. And as a result, Moses changed the course of history of the children of Israelites. We remember the same story, a similar like story, a little girl in the house of her masters in Syria in 2 Kings chapter 5. When there was a problem, she remembers what she was told of in her home back in Israel. And so she changed the course of relationship between two countries, Syria and Israel, when she brings solution to her master Naaman. And we also remember the story of a woman. She was nurtured by her uncle. And when the time matters, in the palace of a king, she stands up to change the policy of the day and the law of the day to rescue her people. And that was Adasha or Esther. Lord, as women and as men, this evening we have learned so much. We have been admonished, just like Miriam. In our society or in a foreign land, in our offices, just like the unlikely missionary girl in the home of her master Naaman, and in the palace of a king, just like Queen Esther, to change the policy of the day and the law of the day, to bring redemption to her own people. Help us to be like these three women, to go out there and change the course of history, to change the laws that is not beneficial to the society that we found ourselves in, to advocate for what is right, for what is true and just. And when we do that, PNG will be a better home for us. The Pacific will be a better home for us, and not only for us, but the generation to come. That will be a place that we love so much to find ourselves in and to live in. Although the society changes when we change that, when we stand up, when we become doers of what we learn today, and not only hearers of what we learn today. Lord, we will now depart from here and go to our homes, just like the children of Israel. Your presence was like a fire in the night. So be it that your presence be amongst us during as we make our journey in the streets of Port Moresby, wherever we come from, to meet with our loved ones. For this we ask all in Jesus' name we pray. Amen.
Thank you, everyone. Our program has officially ended. I thank you all for your time and for staying with us here. We have our cocktail reception outside. Thank you.